Special counsel Jack Smith now trying to breach Donald Trump's attorney-client privilege. He's saying Donald Trump is going to be using an affirmative defense. He's going to be saying that Trump is relying on his lawyers to justify his behavior in 2020, to justify the insurrection and all of that. So Jack Smith says, okay, if Trump's going to be saying I was just following my lawyer's advice, then Jack Smith should be able to get to see what that advice was. These are communications that are ordinarily protected, but if Jack Smith can breach that, that's a pretty big deal. And Trump, at this moment, is not even officially using this affirmative defense, okay? Donald Trump has not filed a notice in the court of law saying that I am going to be invoking that I was relying on my advice of counsel. Never come up. But he's made other statements on Truth and elsewhere. And so Jack Smith is saying, well, we think he's going to be using this defense. And so we're preemptively trying to breach his attorney-client privilege right now. And I know this might sound crazy, like you're like, what, Rob, what are we in, like bizarro world? I thought this was the United States and the government couldn't just ask the judge to shatter the relationship between the defendant and his lawyers on their own, right? The government just asks for it. And we're in Judge Chutkan's courtroom, and so we don't know where this could possibly go. Judge Chutkan has already said Trump really doesn't even need to read the evidence against him, in this case, the discovery, because it is so monumental, the amount of it is so monstrous that there's just not enough time for all of Trump's lawyers to read all of it. And the judge said, well, we don't really care about that. That's your problem, not mine. So now, if the judge finds against Trump, what are we going to see? Are they going to go after all of his attorney's communications and see what's inside there? Because why not? They're already prosecuting him and breaking 234 years of American tradition to do it. So why not what else? Well, we'll look at what Jack Smith and these so-called prosecutors have submitted, and we'll also see what the proposed order looks like, because this is what they want the judge to sign off on that would give them all this extra power to go look at Trump's private communications with his lawyers. So here's the motion. And you see, it is the United States of America versus Donald Trump. And unlike another motion that we'll read in another segment, this one is written by Thomas Wyndham. We've been used to seeing Molly Gaston on some of these cases, but this one's a little bit more technical. Molly's kind of the highlighter person. And so they put Thomas Wyndham on this one. And he's obviously with Jack Smith's office, a little bit more senior attorney, I would imagine. And here is what he argues. The same judge who has refused to recuse herself despite making insane statements that, in my opinion, obviously show her bias. She has refused to allow Trump to get any time to actually listen to the evidence or to read the evidence. And we talked about how it would be 8 to 10 Washington monuments. And so now we're going to throw another opportunity for her in the case to really stick it to Trump by shattering his attorney-client privilege. Your Honor, Judge Chutkan, this is Jack Smith's opposed motion, which means Trump is already opposing this, obviously. And they say that we want formal pretrial notice of Trump's intent to rely on advice of counsel defense. So we want formal notice. Okay, we want to put this in writing. They say, Judge, Donald Trump has provided public notice. Okay, so Trump is saying stuff out there in public. They want him to shut up too. They want to gag him for that purpose as well. But he has said this in public, not in court, that he intends to rely on an advice of counsel defense at trial. And they're going to walk us through some of Trump's statements, and we'll see. Now, when a defendant, in this case like Trump, when he invokes such a defense in court, he waives attorney-client privilege for all communications concerning that defense, and the government is entitled to additional discovery and may conduct further investigation, both of which require further litigation and briefing. Because Trump said something in public on an interview or on tweets or whatever, we think that he's going to do it, and so you better give us the right to go in and just investigate all of those communications, because we said so. And this is going to Judge Chutkan, remember. To prevent disruption of the pretrial schedule and the delay of the trial, the court should exercise its inherent authority to require Trump to produce notice in court of his intent to assert that defense by December 18th. And through counsel, Trump obviously opposes this motion. Why are we going to tell you about our defense? You want to know what we're going to argue? Would you like our defense theory as well and all of our work product? So here's the background. This is Jack Smith and his prosecutors writing. They say, during the course of the government's investigation, at least 25 witnesses withheld information, communication, and documents based on assertions of attorney-client privilege under circumstances where the privilege holder appears to be Trump or his presidential campaign. So they're saying a bunch of people that we tried to get evidence about or on or get to turn on Trump, they all invoked. They said, well, we're not talking to you. So these included co-conspirators and former campaign employees, so other people who may not have been charged, the campaign itself, outside attorneys, and a non-attorney intermediary, and even a family member of Donald Trump. These are all people that said, I can't talk to you, attorney-client privilege. Now, in the time since the grand jury returned the indictment against Trump on August 1st, the defendant, Trump, and his counsel, his lawyers, have repeatedly and publicly publicly announced that he intends to assert the advice of counsel as a central component of his defense at trial. Trump saying, I'm innocent, man. I was the president, okay? I was following a bunch of lawyers. And we've talked about this here before, okay? A number of other people who've been charged or alleged to have been involved as maybe unindicted co-conspirators were members of the Department of Justice. They were all lawyers, okay? Rudy's a lawyer. Sidney's a lawyer. Jenna Ellis is a lawyer. There's all sorts of other people who all got caught up in this. And so Trump, who is not a lawyer, is relying on Department of Justice officials and other legal experts with law degrees telling him that he has a valid claim here. And by the way, I agree with him. And we've talked about it. Now, you might say it was a questionable maneuver, like it's never happened before. That's true. And you might say that maybe it's not in the best judgment to push it as far as Trump did. You might have those opinions or whatever. But the fact is that it wasn't illegal, and it still isn't illegal to exercise and to investigate your claims in this country. It would be like if a defendant charged with a crime was prosecuted for defending himself. They say on the night of August 1st, for example, Trump's lawyers told a national audience on Fox News that the defendant had, on advice of counsel, a very detailed memorandum from a constitutional expert. Footnote 1, Fox News. So some lawyer for Trump, don't know who it was. So some other person, a constitutional expert, did some research on the case. Incredible. They got outside opinion and they got some research done on their legal case. Incredible. Wow. This is what happens in the law every single day. So they have a detailed memo doing some research. Hours later, the defense counsel argued that Mr. Trump had the advice of counsel, Mr. Eastman, who was one of the most respected constitutional scholars in the United States, giving him advice and guidance. The following day, defense counsel was asked on NPR, talk a little about your legal strategy and give us a summary of your legal defense to these criminal charges. And defense counsel responded, said, well, it's not a big surprise. Trump got advice from counsel, very, very wise and learned counsel, on a variety of constitutional and legal issues, all talking about this publicly. Now, 3 days after Trump got arraigned, Jack Smith and the prosecutors say that Trump's lawyers made appearances on a circuit of Sunday news shows. On NBC, defense counsel explained, they said what Trump's being indicted for ultimately is following legal advice from John Eastman. And one thing's for certain, President Trump acted under advice of counsel when he petitioned under the First Amendment, when he petitioned Mr. Pence, and that's legally protected speech on Meet the Press. So likewise, on CBS, defense counsel claimed that Trump, quote, believed a certain course of action described in the indictment was appropriate because he was following the advice of John Eastman. On CNN, defense counsel argued that the conduct alleged in the indictment was sanctioned. In other words, Trump could do it because Trump was following the advice of his lawyer. Weeks later, Trump himself explained in a Twitter interview, probably with Tucker, that we had some lawyers, not all, but we had some lawyers that said a particular course of action described in the indictment was appropriate, right? And that's exactly right. Not all lawyers agreed with Trump. A lot of them didn't. And Trump is still allowed to pursue lawful courses of action. And at the time, Mike Pence had a ton of authority to do certain things. And we know that because they changed his authority after the fact. So on August 28th, the court entered the pretrial order to organize pretrial proceedings. They're telling the judge this. So Trump made those statements before you scheduled the deadlines here. Among other reasoned deadlines therein, the court set December 18th as the date for the parties to exchange lists of exhibits. And so the government's now going to say, we need to know about all this so that we can be properly prepared. By that date in December, the defendant will be required to identify, if he's not already done so, any exhibits that Trump is going to be using in his case, including exhibits that are supportive of this advice of counsel defense. Now, so an affirmative defense is saying that, yes, I did the conduct, but I was allowed to do the conduct. So you can often think about this as like self-defense. Maybe you're charged with assaulting somebody. Well, you punched that guy in the face and you broke his nose. Oh, well, technically that's an assault because it's a physical conduct. Your hand hit his face. But you might say, I have an affirmative defense to that. I was acting in self-defense, and so that negates the criminality of the original assault. Okay, so you're admitting the conduct. You're not saying, I didn't hit the guy. You're saying, yeah, I hit him, absolutely. But it was self-defense. And so depending on your jurisdiction, it depends on how you prove that up and so on. But for our example here, they're saying Trump is saying that, yes, I did these actions. I made the text. I made the phone calls. I said the thing, blah, blah, blah. But I was allowed to do that because I was following advice of counsel along and amongst other things that would immunize him here. So they're saying here, Trump, because he's using this affirmative defense, he's going to be required, the burden is going to shift over to him. He's going to have to make a showing of this. He's saying he relied on counsel, so he's got to put some evidence up. The defendant, Trump, will be required to introduce evidence that that 1, he relied in good faith on the lawyer's advice, and that his course of conduct was in fact legal. Okay, so he's got to, prove both of those things. And number 2, he made full disclosure of all the material facts to his lawyer before receiving the advice. So his lawyer would assume some of the liability because Trump told him everything and his lawyer did the best he could, and the lawyer gave him bad advice, but it's not Trump's fault. And Trump relied on it in good faith and thought he was following the law, but he ultimately wasn't. If the defendant satisfies that the burden to produce evidence that would support this defense, if they can meet that standard, the court should then instruct the jury on the defense to tell them that Trump has made this claim, he's proven up some part of this, and then the government retains the burden of proving the mens rea beyond a reasonable doubt. Okay, so we don't have to talk about, in criminal law, we talk about two things, the mens rea and the actus reus. In order for many crimes to happen, you got to have both of them, a guilty mind and a guilty act. Mens rea is a guilty mind and actus reus is a guilty act. You put them both together. They're saying here, okay, just like in the punch case, right, the physical act happened. Trump made a certain statement or said certain things or somebody threw a certain punch, that happened. But what was the mens rea behind it? What was the thought process? Why would that person in the self-defense position believe that a reasonable belief that they were in a position where they could exercise self-defense? Why would Trump have the mindset that he could do these things? And so if Trump says, I was relying on counsel, the government doesn't have to prove anything about the underlying act, only that Trump didn't actually believe that. They just kind of got to get into his mind. But they want this to be clear. They want Trump to figure this out now. They say, in invoking the advice of counsel defense, and Trump has not officially done this yet, okay? So they're just saying Trump has done this because of his prior statements. He's not formally filed anything yet. He probably hasn't even read the discovery yet. In invoking the advice of counsel defense, he has not done it, but they're just thinking past the sale, right? They've already told the judge he's already done it. The defendant waives his attorney-client privilege on all communications concerning the defense. Wouldn't that be nice? They can just crack open the shell and open the floodgates for a defense that Trump has not even invoked yet. They've just been talking about it on cable news, which they're allowed to do. Accordingly, once the defense is invoked, the defendant must disclose to the government. And this is really what they want. Like, could you imagine? They'll throw a party at Jack Smith's office because this is what they're going to get. All, quote, communications or evidence that Trump intends to rely on to establish the advice of counsel defense. So a lot of private convos between the attorney and Trump, and any other privileged communications that the defendant does not intend to use at trial, but are relevant to proving or undermining it, okay? So it's, the floodgates are open. They can start demanding all of the communications between Trump, even if he's not going to use that, to undermine the very claim. And they say, accordingly, Your Honor, waiting until the eve of trial, or worse, when jeopardy attaches, for them, like for the defense, this is better, okay? For Trump's perspective, you want jeopardy to attach. When the case gets screwed up, they can't bring it back again. But they want to get this all figured out before jeopardy attaches, because that's how they get an advantage. So they say, Your Honor, we can't possibly wait. Like, what happens if Trump brings this up right before trial and he catches us off guard or something and we don't know? And they say, we better do it now, or worse, when jeopardy attaches, which, after the jury's impaneled. To raise an advice of counsel defense risks causing substantial disruption. They don't want their prosecution disrupted. That's the point, by the way, okay? The defense hides their cards until the last minute. In fact, sometimes the defense hides their cards throughout the entire trial. Call it a shiny object. You just have this shiny object you keep waving around in front of the prosecutor. They think you're talking about this the whole time, and your closing arguments like about this. Boom. So, but they don't want that. They want to know right now what Trump's arguments are, especially if it's going to give him an opportunity to go get all of the privileged communications. So it would cause substantial disruption or delay, which is what the defense intends to do, and that's right, their right to do it. Particularly in this case, given the number of attorneys involved. Yeah, it's the president, hello. So they want to avoid such disruption, which again, favors them. It's like taking the timeouts away from the other team or something, right? Because they don't want you to stop them when they're kicking their field goal. It says courts in this district and others have concluded that while the federal rules of criminal procedure do not address this defense specifically, you see what's happening here? To avoid disruption, courts in this district, now we're being very careful here, this district, where are we? We're in Washington, D.C. And others, we'll see which others, have concluded that while the official rules of criminal procedure do not address this, they don't talk about advice of counsel, they still say, Your Honor, judges retain inherent authority to order defendants to provide formal notice before trial. See that? So it's not in the rules, Your Honor. And this court, which is an aberration of justice, in my humble opinion, that's taking place in Washington, D.C. That's not the same as other courts. It's far outside of the norm. But he's writing to Chutkan saying courts have broad discretion to kind of do whatever they want. They can impose pretrial notice, and the majority of district courts have considered the question and have exercised their inherent authority. So they give us a bunch of examples saying other judges have done this before, Your Honor. Look at all these examples. They have to distinguish this because this is not, I would guess, I haven't done independent research on this because we're just going through their motions, but I would imagine that they've got a bunch of bad case law because they're distinguishing it here. So as we saw, this mechanism is not even discussed in the rules, the federal rules of criminal procedure, the big manual, the big book that everybody goes to. It's not in there. So they just say, well, Judge, just kind of make it up. Other judges have done the same. They say a number of courts in cases unlike this one, have denied the notice. Okay, so Trump wins in a number of courts. He wins, but Trump's case is different than this. So he would win if we go by their standards, but this is why his case is different than their standards. And they give us some pretty big cases. United States versus Ray, Southern District of New York. They declined to impose a notice requirement, saying that there's no consensus among the federal courts. So here's this one, Eastern District of Tennessee. We find that there's no good cause to compel the defendants to provide notice before trial. Yeah, the defense needs to explain all the theories of their defense. Another case from the Eastern District of New York, 2017, concluding here that the prosecution in the case had not established a right to pretrial notice of the defense. Here's another one, Eastern District of Kentucky, declining to require notice of the defense pretrial. It's like you have to give the playbook to the prosecutors, but we're not in Kentucky, are we? We're not in the Eastern District of New York, or we're not definitely not in Tennessee, or the Middle District of Florida. We're in Judge Chutkan's courtroom. So they say, Your Honor, look, this is why they're writing for her. They say, look, hey, by the way, this one came out of Middle District of Florida, 2008. Defendants are not obligated to put on any defense, and except for suit and enumerated defenses, which must be disclosed prior to trial, defendants are free to make that decision at trial. You can bring your case and put your case on when you walk into the courtroom. You don't have to give the prosecutors like options. Here are the 3 tactics we're going to use. Try to guess which one we're starting with. So here's the government. They continue. They say those out-of-circuit cases are readily distinguishable. Okay, those are from Kentucky, Judge. We're in Washington, D.C. We're better than everyone else. We're better than Tennessee and Florida. So we can distinguish those cases. And the factors that animate their contrary rulings are not present here, okay? They said that you don't get access to Trump's defense playbook, but here's why you should grant them here. Some courts have refrained from requiring notice because it would force the defendant to reveal an intended defense before trial. But here, they say Trump has already broadcast to the world that he intends to rely on this defense. Okay, they are the dumbest people. Just because you say it doesn't mean you have to use it, okay? You always have options. You might use that defense. You might use another defense. You might use 100 defenses or no defenses. Just because you say it publicly doesn't mean that you're going to actually use it. And it's wild to me that the prosecutors are basically saying that they can infer this is his strategy and therefore they get access to the keys. Another court expressed concern that requiring the defendant to give pretrial notice would not place reciprocal discovery burdens on the government. Another issue. Here, as explained below, Jack Smith's team writes, related non-privileged discovery already in possession of the government has already been given as part of our robust discovery productions, which are not very robust at all, as we've learned from the defense. Courts have also denied pretrial notice, meaning you don't get the playbook, because the defense was unlikely to arise. Here, though, given the nature of the charges and the defense, little doubt exists that the defense will arise in opening statements and during the questioning of the government's witnesses, and it may even affect jury selection. So just because Trump has said it publicly, they're saying, now, Judge, you have to just, make him say it officially, and that way we can get an advantage as this trial moves forward. Even though other courts, other jurisdictions that are not DC don't do this, and the rules don't say anything about it, you should do it anyways. And we know where we are. We're in Chutkan's court. So they continue. All right, Your Honor, now that you know all of that, Trump has made public statements about his reliance on advice of counsel. But he's not provided formal notice to this court, a notice that would trigger discovery obligations. And they're like, we really want those discovery obligations now. But by December 18th, the defendant is required to produce any exhibits, including the ones that include advice of counsel. And to promote fairness and efficiency, by the same date, he should also be required to provide formal notice of his intent to rely on the defense and then promptly produce the required discovery. So Trump has a lot longer, okay? Trial is not scheduled in this case until March. And other circuits have said, you don't have to bring in this defense until trial, till the day of trial. And they're saying, Your Honor, we want at least 3 months, provided this trial doesn't get postponed at all, to comb through Trump's attorney-client privileged materials. They say requiring notice promotes fairness for the DOJ. Your Honor, Judge Chutkan, fairness dictates that the government should be provided notice and discovery about the defense sufficiently before trial. As another court found, 3 other enumerated defenses, like alibi and insanity and public authority, which are other affirmative defenses, right? We don't see in there advice of counsel. There are rules for the other ones, like alibi. You got an alibi? You say I was in Hawaii when something happened. I couldn't have been there. Well, we can, show that up. So we got to have disclosures about that. Same thing with insanity. You can challenge that, right? Give them psychiatric evaluations. So advice of counsel is not on the list. But they say it's close, though. They say in other instances, we have gotten pretrial notice. And this really shares a basic characteristic with the others. These are fact-intensive defenses, and they're going to create substantial problems of fairness for the poor DOJ if we learn about it for the first time during trial. So they want advance notice. So given Trump's obligation to provide discovery that arises from advancing this defense, Trump should not be permitted to pepper his exhibit list with documents that support his advice of counsel defense. Do you see what they're writing? He shouldn't be allowed to just fill up our documents. And these are the same people who delivered 8 to 10 Washington monuments full of discovery to Trump. So they don't want extra paperwork. And they shouldn't allow Trump to be coy with formally noticing the defense so as to withhold discovery, undermining it, and then ambush the government with the defense during trial. You're going to represent and defend your own interest in trial, and you're not going to notify us about what you're doing? They say the defense does not have a constitutional right to withhold all defense and surprise the government. Well, that is true. In some instances, you'll see situations where in the Hollywood movies, you'll see like a witness like springs through the doors at the last minute. It's like, I've got the gun, not guilty, whatever. That doesn't happen. But you would disclose a bunch of stuff. They would disclose a ton of exhibits, hundreds and hundreds of exhibits, okay? Thousands of exhibits. They've got millions and millions of pages that go to Trump. So Trump can't pepper his witness list, his exhibit list with his own exhibits showing his defense. That's the point. And you pull him out at trial. Oh, so we're going to impeach this witness with this. And they use their exhibits as they want. Now the government wants them to notify them about their legal defenses. So in addition to having publicly advanced the defense, they really don't like Trump talking, and they're trying to make him pay for it. The defendant knows what information the government has and does not have that might support or undermine this defense that he was relying on counsel. The government produced in discovery the privilege logs for each witness who withheld information on the basis of the privilege claim on behalf of Trump or his campaign. So we know who the people are. They already told us 25 of them. And in some cases, Trump's campaign was directly involved in discussions regarding privilege during the course of the investigation. In other instances, and meaning they couldn't get that info, right? They couldn't get access to it because it's privileged. In other instances, the government produced court orders requiring the production of the material that was claimed. Compelling Trump to provide notice and thereby discovery would be reciprocal of what the government has already produced. So in other words, we know what we've got. Now we need to know what you've got. They say defense counsel has already publicly identified one attorney, John Eastman, as we know, whose advice the defense intends to rely on at trial. And they're making that up. They've just said that on TV interviews. But you can say a lot of stuff on TV interviews. A TV interview is not the court of law, prosecutors. And the government has produced in discovery substantial evidence regarding his attorney and his advice and relevant search warrant returns. So they did get access to some things. And any material relevant to the attorney's advice that remains shielded should be produced to the government at the earliest date. So we want to see the rest rest of Trump's attorney communications. They say, Your Honor, Judge Chutkan, in filing this motion, the government does not concede that Trump is entitled to offer an advice of counsel defense at trial. We don't think we're not legitimizing that, or that such a defense is supported by competent evidence. Indeed, if the evidence disclosed by Trump shows that the advice of counsel is unavailable as a matter of law, in fairness, the government should be permitted to raise the matter in advance of trial before questioning an argument. Juxtaposed against such a defense, the indictment alleges that Trump ignored the advice of his attorneys and was not acting in good faith, and the court may need to hold a hearing in advance of the trial to determine if he should be allowed to investigate. So remember, the government, they've got a bunch of other witnesses who say that Trump was acting beneath the standard of care, okay? He was acting maybe unreasonably or criminally, according to Jack Smith, because he was doing things that were so outside of the advice of counsel. It was so abnormal. Now, Trump is saying, and I agree with this, that there is a different legal theory that he was relying on that was not criminal, that was much more aggressive than the other DOJ people, and he's free to take that path. It happens all the time. It happens every day. Lawyers talk to their clients every day, and they say, hey, we've got a range of options here. This is the most aggressive thing that we can do. If we go this route, we might win. We might go to trial, and you might found not guilty, or you could be convicted, and you could go to prison, okay? Now, on the other end, we've got this very safe option, which is we take a plea deal, you get probation, you do community service, the whole thing goes away or whatever. And you might have a lot of people, most people, in fact, 99% of people are going to take that other side. It shows up in the plea deal numbers in criminal courts. But 1% or 2%, they're going to go to trial. And Trump is absolutely the 1%er, all right? He took it to trial. He took his case to trial in front of the American people. And then the FBI and the CIA set him up. But the whole thing is that he's allowed to pursue that. So they say that if Trump is going to make this defense, they're going to bring in the advice of the other lawyers on the safe team. And so Trump is going to have to bring in the advice of his other counsel. They say, finally, Your Honor, while fairness warrants pretrial notice of the advice of counsel defense in this case, fairness, this is our government prosecutor talking about fairness in Washington, D.C. on the January 6th case against a 4-time indicted political opponent of the state. Requiring it imposes no unfairness on the defense, other than the fact that their entire thesis gets disclosed to you, and you get access to all of their private communications between Trump and his lawyers. Aside from that, given his extensive public statements, Trump cannot complain that formal notice will prematurely or unfairly reveal a hidden strategy. And since Trump must produce exhibits in support of this by December 18th anyway, he must produce the exhibits, okay, in support of advice of counsel defense, but he doesn't have to label them as advice of counsel defense. You understand? Trump could just say, yeah, I'm going to call this guy and this guy and this guy and this guy and this guy. Here's my exhibits, and then do it. But they want it done now. They want it notified so that they can go crack into the emails and the other communications. They say Trump is going to suffer no prejudice, and it's not even going to hurt the defense. After all, producing and identifying an otherwise privileged document will operate as a subject matter waiver for all related communications. A lot of law here. There's no unfairness to requiring Trump to provide formal notice that then triggers the requirement of producing the discovery. So Trump files the notice, they get to go open the floodgates. And they also say, Judge, by the way, we like efficiency here. We like how you just don't let Trump even read his evidence. Requiring pretrial disclosure will also prevent disruption of the court's schedule and further judicial efficiency and allow the defendant to produce the discovery that such a defense would entail. Trump publicly claims to have multiple lawyers providing advice during the post-election period, and at least 25 witnesses withheld information based on attorney-client privilege grounds. So the process of disclosure and review, followed by the potential litigation, is going to be time-consuming, Judge, and so we've got to do it in advance of trial. Otherwise, we know Trump's going to bring it up and it's going to screw up our case. So the discovery and the investigation process surrounding this advice of counsel defense may raise additional issues prior to the trial or require a bunch of briefing and additional inquiries from our side. So if Trump fails to provide timely notice and discovery, the court should preclude Trump, you see this, from even using the defense at trial. So if Trump doesn't notify us, if you say you've got to notify Trump of what you're doing by December 18th and you don't notify us, you now lose the right to do that at trial. So claim it or lose it. Use it or lose it. So they're trying to stop that as well. Pretrial notice is all the more warranted here, and the defense is likely to arise in the opening days of trial. They say, here's what we expect. Trump may wish to discuss it even in his opening statement or on cross-examination. Trump could elicit privileged information that was previously shielded from the government, and it could sandbag the government and necessitate an interruption of testimony or an adjournment. Oh man, they don't want to get sandbagged like their boss, Joe Biden, can't even walk across a stage. That's the point, DOJ. That's the point. That's why we bring it up out of nowhere, so you don't get to know it. And the government should be shielded. Now, you're sitting here, Judge Chutkan's like, oh my gosh, we don't want the government to trip over the case in the middle of the trial, saying there is no benefit in allowing defendant Trump to wait until trial to advance his defense. There is to Trump. Rather, efficiency requires that the government receive notice and discovery in advance of presenting its case so that they can fairly prepare for direct and cross-examination and to avoid recalling witnesses either in its case in chief or in rebuttal. This reads, it's like a whiny child, honestly, like complaining to the principal. And you know what? It's the principal's kid. It's like, oh, great. This kid's getting everything that they want. Notice should be given when exhibit lists are due. So they're already going to notify you about the exhibits, which again are not categorized. They don't have to tell you, we're going to use this exhibit for this defense. Once the decision is made to require pretrial notice, Judge, and I expect Judge Chutkan to do it, the court should set the deadline most reasonable to accomplish the twin goals of fairness and efficiency. Notice how we don't see presumption of innocence or due process or equal protection under the laws or promoting candor between attorneys and clients. No, they just don't want to get sandbagged in their own trial. And it's fair for them and it's more efficient for them. The deadline most directly related to the advice of counsel defense, most directly related, it's not an actual deadline for it, is December 18th, 2023, the date on which the parties are supposed to exchange documents anyways. By that date, Trump is already required to provide functional notice by way of exhibits, which is not true, right? You don't know. You can file 100 exhibits and you don't know where they're going, that he intends to offer into evidence. And they're saying that, that's just the trigger to get them access to the rest of his attorney's materials. It boils my blood. The court should formalize Trump's requirement to produce discovery by requiring notice at that point. Trump's intention to pursue advice of counsel has a direct bearing on the exhibits he will use. Presumably, he's going to try to rely on, for example, the quote, very detailed memo from a constitutional expert his counsel described in an interview, and he's going to need that in his exhibit list. He would also need to identify any exhibits to ensure that he made a full disclosure of all material facts to his attorney, and so on. And so this could come in the form of many things: text messages, attorney's notes, communications, and all of that, which would result in a waiver over the other privileged materials. So he's going to disclose those anyways. We're going to get access to those anyways, which gives us access to the other things anyways. So Judge, just let us do it now. Requiring Trump, so making the defendant give formal notice at the time he designates exhibits, is a natural complement to what we do. Parties must also submit joint instructions for voir dire and other things, and we won't be able to submit an effective joint proposal until we know what Trump's intent is, which is amazing, like that they care about that, because Trump says that we can't know what our defenses are until we read the discovery, but they don't care about that. For example, they say Trump's asserted defense may inform what questions the parties and the court may want to ask during jury selection, and the court would benefit from having this in writing, especially the part on advice of counsel. The Red Book does not contain details on what we should do about this, but in more simple cases with fewer attorneys on whose advice a defendant purportedly relied, courts have ordered pretrial disclosure in other cases. And in other cases where they didn't, those cases are distinguishable. We've got prudential reasons and saying we know that a lot of people are going to be coming in, at least 25 witnesses here. So given the potential number of attorneys and the breadth of advice that's involved in this case, Trump should provide notice about the identity of each attorney who provided advice, the specific advice that was given, including whether the advice was oral or written, the date on which the advice was given, and the information that Trump communicated or caused to be communicated as well. Do you see all of that? They say in conclusion, the parties, the jury, and the public have an interest in an orderly and efficient trial. The court should build an appropriate interval into the pretrial schedule to ensure that we get access to everything we need from this new defense that we're claiming Trump is invoking, even though Trump has not invoked it. For that reason, the court should enter an order requiring Trump to provide his notice by December 18th, and that way they can open up the floodgates and see what's inside. Here's the proposed order saying if Trump serves notice, he must at the same time produce in discovery all communications or evidence, as well as the things he does not even intend to rely on at trial. So they submitted this over to Washington, D.C. They want Judge Chutkan to sign off on it, and I I have some concerns about this. I think that she might require him to post notice, and we'll see what he does. He might forego. Now, the question is going to be, what happens if Trump forgoes this? He says, no, we decide that we're not going to use this defense because they don't want to open that Pandora's box. Then I wonder if they're going to say that they should still get access to it anyways because he's communicating it. Then they would say that he's going to be precluded from using it at trial anyways. And so we'll see what Judge Chutkan does. I think she's got a strong inclination to give the government access to all Trump's attorney-client privileged information. We'll see if she does, and of course, continue to follow. Now, there was also another update in Florida. This is Judge Eileen Cannon. Not a big update, but we're talking about deadlines and orders, and so there was a temporary stay on the SEPA deadlines in that case as well. So that trial might be moving around a bit. We're not sure, but we do have some pretty sizable updates from Jack Smith now trying to breach Trump's attorney-client privilege, which is a big, big thing. If that happens, that could be a big problem for the Trump defense. We'll continue to cover, my friends. Thank you for joining us as we do. Thanks for subscribing and hitting the like button wherever you're watching it, and we'll look forward to seeing you on the next one.